hello. Good morning, everybody. Hello. Saturday, such that it is. Good morning. Hello, small fry. Oh my goodness gracious. Oh my gosh. Hello, everyone. Good morning. I'm not really a morning person, so I apologize on the front end of that. So much going on. I know. So, hello, good morning. Hi, J Jack. Hello. Is it Jilt 54? I have had so many people asking me about the DOGE Social Security question here. Oh yeah, not a morning person. Oh, I know. Last night I was able to finally download my last 3 lives, so I will put them up on TikTok on the tube today, and so this one I hope to make sure to have go up as well. So it's been busy, everybody. Hello, June Marie. Hello, Doughboy. Hello, Megan. Welcome in, everybody. I know this isn't really my usual time, but this is the time I had to do this. Now, tonight I will be live again, and I will be doing part 2 of the Bondi ethics complaint. We made it halfway through last night. We'll have to do the second part tonight. But this morning, hello. Well, it might be we're a medium spice level. Medium. Hello, Connie. Welcome in. Hello, Allison. Yes. So this morning, though, I wanted to talk about what's happened with the Supreme Court regarding DOGE and the Social Security situation, because that's really having some interesting reporting going on. That's kind of getting a little bit bonkers. So I thought I would take everybody actually through what the case is and what's really happening here, so that we didn't have so much crazy town on our hands. Yes. So I've printed out everything that I think we need in order to figure out what's going on here, because I think one of the most important things to note here, we've got a dissent, by the way, from Justice Jackson, but hold on here, everybody. Let me make sure. So, here we go. Getting myself sorted out here. No, that's not it. Okay, where'd it go? Hold on just a minute. Here we go. I will get sticky note put on here. Okay, this and this and this, and this and this and this. Oh boy, I organized this so I'd be all ready, and then here I am like, what? All right, here it is. Nope, that's not it. Oh my gosh, okay, hold on here a second, everybody. Because what we got from the Supreme Court was just like this little paragraph of what was happening here. We have this dissent by, good morning, by Justice Jackson. But the actual ruling itself here is just a sentence. Let me see. Let me find it here. It's 1 page, so it's, I think, snuck in here. Okay. Go with that. Yes, of course. I tell you, there's a lot of paperwork going on in my house. Lots of paperwork here. Now, I just read it, so I know I have, oh, here it is, everybody, look, it was hiding at the bottom. That's what I was looking for. This one page here. So, what the ruling was yesterday was just this paragraph. That's what happened. It said that the stay that was requested from the Chief Justice is granted. This is it, all right? So this little tiny paragraph, again, we have a dissent from Justice Jackson. She disagrees, and we'll go through that dissent. But this is it. So a lot of people are like, we have this big ruling, but we really don't. We really don't. I mean, it's they granted the stay because it's likely to, win, but it doesn't mean it will win for sure. So I think that's important to note. Folders or binders for cases. Oh my gosh, folders. I used to do binders, but then it's just like, it got to be a lot. All right, so I will take you through again what has happened here, because the decision is just a very, very simple one. And then we have Justice Kagan, and she said she would have denied the application here, and Justice Jackson and Sotomayor actually have a dissent that we can read through here. So this is really it, but it seems like it's really being misunderstood. Yes. Well, right, Chelsea. There's just a lot to it. There's a lot to it. So let's get started, because how else do you want to start your Saturday morning than digging through the legal ins and outs of Social Security Administration lawsuit. All right, so here we go. Well, it's a matter of, and I think this is such a valid point. Oops, sorry, everybody. Just a minute. Is that important? Oh my gosh, good morning, good morning. Oh, morning's not my favorite, everybody. Here we go. Let me see if I can fix this. Okay, hold on. Here we go. Hold on. Nope, not important. Here we go. Right, the amount of protection that you have on your information, it has a huge variable. It will absolutely depend on what it is and what it's for, and whether or not there's a law actually in place to help you with it. So you don't automatically have a privacy protection on any of your information. It has to be really spelled out, because, oh, thank you so much. Because, right. Because the problem is here, there is no right to privacy in the Constitution. There's no right to privacy. This is what got the Roe v. Wade case tangled up, in my opinion. And then Dobbs came in and just was like, nope, we're not going to do that. There's no right to privacy. There's no right to privacy for your stuff either. The only thing in the Constitution that has anything to say about your papers and effects and information is under the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effect against unreasonable searches and seizures shall not be violated. All right. Now you might say, well, that just says that we don't have to have that, but you can still have searches and seizures of your stuff. It just has to be reasonable. See how they did that there? See how that language is? So you don't have a right to privacy. You have a right against the government unreasonably searching your stuff and seizing it. Now, what this unreasonableness means is what we go back and forth on. So we've got warrants here also that require probable cause. And that's the warrants clause. And it says, you need to have at least a bare minimum here when you get a warrant to go search. And that's it. So what we have for the right to privacy is in what we call the penumbra, or the water blots of the Constitution. So it's this clear inference out of the Fourth Amendment that you do have protections, but exactly what those protections are and how far they go, that's defined by the courts. Right, and it certainly was before electronic data. It should apply to DOGE. I agree. Yes, so that's the whole trick of it, everybody, is this case, and I've been working on putting together a right to privacy post here, because again, it's not clear. It's not clear. Some may say that it's under the Ninth Amendment, which sets out anything. Well, let me just read it to you since I've got the Constitution right here. Let's just look at it real quick here before I dive in to the paperwork here. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So some people say your right to privacy is in the Ninth Amendment, which basically says just because we didn't write it down doesn't mean you don't have it. It just means, we didn't write it down because we're all intoxicated and stoned. But this piece is basically our catch-all. And then we have here Amendment 10, the powers not delegated to the U.S. by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. And this is the other piece where they're like, oh, the states' right, states' right. No, this just says, there's probably a lot of stuff we forgot to put in the Constitution regarding what needs to happen. And so if we've not prohibited the states, then, they can sort that out themselves. So the Ninth Amendment is really the one that's the catch-all here. So they're like, oh, the right to privacy is under the Ninth Amendment. All right. But it's not clear, is it? It's very vague. It's very, very vague information here under the Ninth Amendment. So your right to privacy is built off of our doctrines that we've set out, which all started really with the case, the Katz case. And this was, I can't remember the year. It was in the late 60s. All right. So forgive me, I don't have the year off the top of my head, but this case had to do with some dude, doing some bad business in a phone booth, and the government tapped the phone booth. And he said, I thought when I went into a phone booth and closed the door, Superman style, that I was in a private area. And the U.S. Supreme Court came in and said, well, we're setting out a standard. And that standard is, well, what's your expectation? All right. What's your expectation of privacy? And that is now the rule that we use, the test that we use when we're determining whether or not that Ninth Amendment or that piece of that Fourth Amendment is going to come in and offer you some protection. All right. So what's your expectation of privacy? Good morning. Tap the phone booth. Heck yeah, they did. Yep, they did. They're like, dude, you got to have a warrant, because they're like, we don't need a warrant. This is in public. They're like, no, you're going to need a warrant. Because there's an expectation. It's an enclosed place. So examples I try to give of expectation of privacy, right? So if you are in your home with the door shut, all right, and, windows closed, shades closed, and the police are knocking at your door, right? Your expectation is that you are protected within your home, right? But let's say that you are in your car driving around and the police are looking at you. What's your expectation of privacy? Is it the same as in your home or not? If you're in your car, good morning. Good morning. Reasonable expectations, right? Right. So they can see you right through the windows. You're driving around, you're in public. So your expectation is reduced, right? So yeah, there weren't doors on phone booths. Exactly. So you didn't have that expectation. Good morning, John. Oh, thank you so much. So you're in public, you got windows, your car, your expectation of privacy is lower than it is if you're at home. But then let's take a look. What about a public restroom, right? So you're in public, you're in the restroom. I'm not talking about the dude's restroom. That's a different can of worms, and I'm not going to look at that business. But if you're in a public restroom, what's your expectation, right? Where's your level of expectation? Probably higher than in your car, but lower than in your home. So what you do then is we kind of go on this continuum and we say your home is the absolute pinnacle of what your expectation of privacy is versus, standing in front of the police, all right? So, and then along this continuum is your expectation of privacy, depending on what's going on and what's happening. All right? If it's sitting out of reach, right, exactly. Why do I need permission to record phone calls then? Now, great question. Here's the deal. This is, and one of the things that's so fascinating is that this is the foundation. Your state can put into place laws that set out privacy and that's what they do because it's not defined very clearly. So they can say like, you can't record two people if they don't know, or where your privacy is exactly. They can do that as long as it doesn't violate the Fourth Amendment. And those can be challenged as well. So probably one of the biggest cases that talks about this very issue is Lawrence v. Texas here. This case was decided, what was it, 2001? It's not very long ago legally. That can't be right. This year's probably wrong. I apologize. It's in the 2000s. It's early, everybody. And this was a situation. Yes. Good morning, Willie B. Hello, hello. So, right. So HIPAA's a little different animal, but yes, you can set rules out legislatively. You can codify different areas of privacy, right? Overall. And that's here is what the argument is that AFSCME's saying. It's like there's a federal statute that provides for it. So what we're going to look at is what's happening then, why the court's looking at it the way that it is. All right, so here, Lawrence v. Texas, this will be our last piece of con law history, everyone, then we'll dive in. So Lawrence v. Texas, there were two fellas, and of course we've got to talk about it here in Pride Month, of course. So we have two fellas here, all right, and they're in their house, and, you know, they're in their house. they're two fellas, they're together in their house, and they're in their living room, all right? Now, in the living room of their house, there's a big window here, all right? So here's their house. This is why I get paid the big bucks for these kinds of visual aids, everyone. So they're in their house, and they're in here, and they're just like, hey, what's going on? What's going on? And then there's an officer walking along here, and he's like, do, and doing whatever it is he's going to do. And so he's walking along, and he's outside. He's on a public place, right? Sidewalk situation. And he looks inside, and he sees what these fellas are doing. And he says, well, in Texas, that act is illegal, right? So that you can't be doing that. It doesn't matter if you're two dudes or two girls, or one dude and a girl, or two dudes and two girls. That act you are doing is illegal under Texas law. Man, everybody, I should be getting awards here. All right, so you can't do that. It's an illegal act. Oh, my goodness. All right, so then he goes, knock, 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 and says, dudes, come on out. And so the dudes come out, and he's like, we're taking you down to the big house here. This is a police hat. And I'm arresting you, all right? And they're like, well, we were in our own home. This is our highest level of expectation of privacy. We are in our own home, and we have the right to do whatever we want in our own home. And, you know, you can't just be walking around and peeking in and telling us, right? Yeah, exactly, Joker's wife. That's right. Without this, you'd have no idea what I was talking about. So the two fellas were like, we're in our own home. And the cop is like, well, what you were doing was illegal. All right. So they go to jail. Now, when they're in jail, they're like, this isn't right. So they appealed to all the way up to SCOTUS. And they said, we're in our own home, and we have an expectation of privacy. So what's going on here? If an officer's looking through our window and coming at us and saying you can't do that, we weren't doing, you know, some kind of clear, like, medication or mind-altering thing that you're not allowed to do. We're just, you know, we're just doing our own business here. And the Supreme Court came in and did two things. And they said basically, like, well, if you're in a public place and you're looking in, if you're on the sidewalk and your curtains are open, that's a problem. That's your problem. Close your curtains, people. Close that up. Don't be opening that window curtain. And the second piece was, this statute is illegal. You should be able to do what kind of acts you want to do in the privacy of your own home. All right, so it was a twofer. So in the end, when it comes to this privacy expectations, if someone's looking in your window, you know, close your curtains. But, or if your house is made out of glass, how can you say, well, you know, you can't see what's going on in my house? Like, that's called plain view, and that's an exception to the warrants clause, all right? And if you're in a public place, you're just looking through, all right? But on the other hand, the act you were doing is private, and the government doesn't need to be in your private business with your acts, all right? So this was another way that they defined privacy and actually, you know, ruled that Texas's statute was unconstitutional. Everybody follow me down that road. We got to walk carefully. All right, here we go, everyone. Let's take a look then at what's going on. This is the AFSCME v. Social Security Administration lawsuit. This is the Social Security information case that we've all heard about. Something that I wanted to also show you, though, before I get too far, real quick, just to give you some idea here. Where did I put it? Here we go. Searching through the papers. Boy, mornings are tough, everybody. They are tough. Okay, here we go. So this isn't the only show in town. DOGE is being sued a lot. So this is from Lawfare. Lawfare is doing an amazing job tracking the litigation here, all right? So the litigation tracker here on Lawfare, you can go and check it out. I just printed this out before I came on here just to show you how many cases we're dealing with when we're talking about DOGE, all right? DOGE is very controversial. A lot of lawsuits regarding DOGE, like a lot. So, you know, when we're saying, oh, DOGE shouldn't have access, like there's a lot of stuff going on and there, you know, we're going for them. It's just a matter of what we're actually going to have happen here. So here we've got a FOIA lawsuit, which is Freedom of Information Act lawsuit. This was just filed here. So we've got a lawsuit against the CFPB, Education Department, Social Security Administration, and VA Department seeking information related to DOGE's activities within those agencies, right? So everybody's after the DOGE. They're saying, what access have you had to all of our stuff? What do you have? They're trying to find out. They're trying to figure that out. Here we've got access to the Department of Treasury. They're like, well, what information do you have for the Treasury? Next, we've got the New Mexico case where they're saying access in violation of the Appointments Clause. So we shouldn't have had that, and you're outside your statutory authority, DOGE. And we have another one here, Crew. This is another Crew case, and we've got records also here in compliance with the Federal Records Act. Again, now we've codified some of our privacy rights, and they're saying here you shouldn't have access to this information under the Federal Records Act. All right. Oh, they're not going to be on vacation. No, they're going to try, but no. So we have another one here, disclosure of documents, communications with other executive agencies, removing board members. We have access to the Institute of Peace, rural development innovations here. And I show you this because I'm trying to show you here that it's not just the Social Security. Everyone's like, oh, Social Security information. No, it's everything. It's everything here. We have also, let's see, Computer Fraud and Abuse Act, then the Privacy Act here, violations of CFAA, Oregon here, dismantling the National Endowment for the Humanities. We have also disclosure of certain documents related to, again, communications with other agencies. So that's another one. Project on Government Oversight is suing here for DOGE's record keeping itself. So not just, what they have access to, but what they're doing with the information they have access to here. And also asking for FOIA regarding the Presidential Records Act here. Next, government here, Social Security Administration. This is the case right here that the Supreme Court's been talking about yesterday. So it goes on and on and on, everybody. It just a song that continues on and on here. Federal Records Act, Freedom of Information Act, Social Security information. We have vendors, employees, and donors information. Let's see here. Department of Labor information, students and professor information regarding student loans and various things. All of that data has been accessed. Let's see, preliminary injunction, disclosure of plaintiff's personal information here. So this is the teachers, American Federation of Teachers. Question, we have, Oh yeah, the Election Assistance Commission. So all of your voting stuff is up here, current and former federal employees. So the employees that have been laid off, kicked out and such, personal information for any federal employees here is also being accessed. We have, let's see what else. Again, another one on elections here. So your right to vote and even through the states. Here we have lack of compliance with FOIA. So DOGE is not giving information to the people requesting it, as is under the law, right? The USAID complete dismantling situation. Here, all of that information has been given to them. We have a discovery order that's being contested. This is the Elon Musk case. Where he's like trying to jump over all of the steps here. Let's see. So American Federation of Teachers, Association of Machinists, Aerospace Workers, National Active and Retired Federal Employees Association, Treasury Secretaries being sued here. And I'm trying to fast forward here. Freedom of Information lawsuit here, and a digital service seeking information again here. 26 former U.S. aid employees, information has been taken here. Democracy Forward here. Let's see, U.S. Marshals has got a FOIA against them with DOGE here as well. So the president of the United States African Development Foundation is suing because they're trying to disband. We've got Alliance for Retired Americans. So anyone who has worked and is now retired, that information's out there. Center for Biological Diversity here. Let's see, nonprofit for civil liberties issues, federal employees as well. Public Citizen State Democracy Defenders Fund as well. Center for Taxpayer Rights here. So this is a taxpayers. Center for Taxpayers' Rights. So not do we just have Social Security, but we have taxes, we have education if you've ever applied for a loan, or if you are a teacher, or if you are a professor, or if you have anything to do with any kind of science, where you've had to use federal funding here. If you're retired here, obviously, if you're in the military, all of your information is there. Even if you're out of the military. All right, so every single place is being accessed. All right, Treasury employees here, and that's the list to give you some idea. And the reason I show this to you is because in this moment, people are saying our Social Security information now, according to the Supreme Court, the stay is in place, meaning the protective order protecting that information is now gone. So we're worried. And so what I'm trying to say is all of this information is also on the line. All right. All of this information is on the line. Yes. So you might say, well, I don't give that much information. No, all of the information is on the line and has been since they put this group together. All the whole time, all of it has been. So if you have given any information to the federal government in any way regarding, where you live, your registration for voting, your banking information, whatever, your birth date, whatever, all of that information here, all of that has been compromised as soon as DOGE came in and started making lists like this. No, you don't even live in the oh dear. Medical records, yes. And that's too where someone had said, well, isn't HIPAA a federal statute? And HIPAA is a little bit of a different creature. It's a different animal here. So that's a little bit different, but yes, exactly. No, all that information's out there, everybody. So, today or yesterday, this isn't some big oh my gosh, look what just happened. No, this has been going on for a while. Does that make anybody feel better? No. Wait a minute. That doesn't make us feel better. Oh my gosh. Yes. Right. So, but what I want to also emphasize here is that when we walk through this case, we're looking at it from a legal point of view. What statutes do we have protecting us? Did DOGE go in legally? Can they access this information when we have certain statutes protecting us already? All right. So here's the case here. This is the number. Now, the full docket of the case, I won't bore you with all of that, but this case has been ongoing. It was filed originally here quite a while ago. I've got it in reverse order. I think it was February it was filed. Let's see here. February. Well, February they had appearances coming in. So let's see when the complaint. Yes, February 21st, the complaint was filed for this particular case. All right. So what's been going on here? What reason was given that gave DOGE the need for this information? Well, right. I mean, they just wanted it, right? They're like, we're trying to update everything, so we want the information. We're here to update the systems. So this was originally filed in February, the first complaint. And let's just take a look at the very beginning of the complaint so we have some idea of what this lawsuit's even about. Because, that's important. That's important to know what we're talking about here. So the complaint that was filed February of 2021, jury trial was requested. So let me take you through just the first couple of bits here, and this will set out for you the entire point. Can they access our bank accounts? Well, are your bank accounts in any way known to the federal government? That's the question, right? So do you have your refunds sent to your bank account, your tax refunds? Right? If so, yes. Yes. All of this is a yes. Here we go. Plaintiff's complaint for declaratory and injunctive relief. Exactly. So yes. Yes, they do. Direct deposit for work. Yep. Or disability. Exactly. Or to pay your loans if you're paying your student loans back. Yes, thank you, John. My eyes aren't so good. So here we go. Let me just put a little sticky note in here so that everyone knows what I'm talking about. It's 2 C's, right? I don't know. Everybody forgive me. It's early. All right. Who's the plaintiff? So the American Federation here, I'm not going to say the full word. So it's AFSCME, the Alliance for the Retired American Federation of Teachers. All right. So they're taking access. Since President Trump's inauguration on January 20th, the U.S. DOGE service and Elon Musk have launched a sweeping campaign to access highly sensitive information systems across multiple federal agencies, unilaterally and unlawfully. DOGE has seized, or at least tried to seize, control of some of the most carefully protected information systems housed at the Treasury Department here, including the IRS, the Department of Education, Department of Labor, Department of Health and Human Services, and Consumer Financial Protection Bureau, the General Services Administration, and the U.S. Agency for International Development, so USAID, and taken hold of all sensitive personnel information at the Office of Personnel Management. As one employee in senior leadership at USAID has put it, DOGE has achieved God mode, meaning full unrestricted access to the agency's digital infrastructure. Let me have footnote number 1 here. And then that's a citation to where that information is coming from. So DOGE's rapid spread now reaches the Social Security Administration, where it has access to some of the nation's most sensitive data, including the financial data, employment information, medical data, and personal addresses of millions of Americans. This is not just an unprecedented data grab, it's an unprecedented power grab. Only once before, as the White House sought to gain access to such personally sensitive information, it was met with swift and decisive responses from Congress, the Tax Reform Act of 1976, and the Privacy Act, putting broad and decisive protections into place to prevent presidential misuse of sensitive personal information. Yet we are once again faced with the executive branch overreach, threatening to review and expose the personal data of millions of Americans without any express authority. and in violation of the many protections Congress and the executive branch have erected to protect against such data mining and misuse. The facts about this assault on federal systems of records are emergent, with new disclosures in litigation and public reporting coming almost daily. With each, the entire picture grows more concerning. So that's just the first couple of paragraphs here in the complaint that was filed. Right. Oh, yes. Yeah, the information is, it's there. All right, so here's the complaint. Let me walk you through again kind of what's been going on in this case. So this is, I want to make sure I have April 17th, because we have we have two letters from the judge in this case talking about how she's been trying to protect this information. All right, so let's go through the first one here, which was filed April 11th. And this, again, we're in the District of Maryland. This is our district judge who has put in place protections. And this is what's been overruled by the Supreme Court. All right, so her protections have been removed. That's what happened yesterday. So here we go. As you know, I issued a temporary restraining order on March 20th. The government noted an appeal of the TRO to the Fourth Circuit on March 24th. Then on March 26th, almost a week after I issued the TRO, defendants filed in this court a motion to stay the TRO as clarified by my letters March 21st. Several hours later, defendants also moved for a stay in the Fourth Circuit. Again, a stay just means pausing of the lawsuit. By agreement of the parties, on May 27th, I extended the TRO through April 17th. And by memorandum and order of March 31st of 2025, I denied the stay motion. The Fourth Circuit dismissed the appeal on April 1st based on lack of jurisdiction. So the Fourth Circuit has refused to hear the case because they said we don't have jurisdiction. On April 7th, the government filed a notice of recent decision and request for reconsideration. In the motion for reconsideration, the government notified the court that the Fourth Circuit granted a stay pending appeal in this case. Here, so we have that. Defendants noted that Judge Agee and Judge Richardson concluded that the plaintiffs in Besant likely do not have standing to pursue their claims. Here, in light of Besant, defendants asked the court to reconsider its earlier decision to deny defendants' request for a stay during the pendency of the preliminary injunction proceedings and any subsequent appeal. Plaintiffs opposed the motion for reconsideration. They asked the court to consider Besant prior case to the extent applicable in the regular course when deciding the preliminary injunction. As noted, defendants expressly agreed to extend the TRO through April 17th. By order of March 27th, I extended the TRO through that date. The hearing on the preliminary injunction motion is scheduled for Tuesday, April 15th. Given the impending PI motion hearing and the agreement of the parties to extend the TRO through April 17th, I shall deny the motion for reconsideration. All right, so we have a TRO in place, and she's getting ready to do a preliminary injunction hearing. All right, so there we go. And this, again, is to protect the information. As indicated, a hearing scheduled for Tuesday, April 15th with respect to the PI motion and a joint status report March 27th. The parties agreed to address the need for witness testimony in their respective briefing, with plaintiffs stating their position in their reply. The government's brief does not address the matter of witness testimony. Plaintiffs, for their part, defer to the court regarding whether testimony from defendants would aid the court's evaluation of plaintiffs' motion. And that's what our district courts do. Our district courts do the work. That's where the evidence is taken in. This is where the witnesses are. This is where the work is done. A recent news article reports that the Social Security Administration is repurposing Social Security's death master file in an effort to pressure immigrants to self-deport. Citation here. The article also mentions that Acting Commissioner Dudek sent an email to SSA staff regarding this project, but no details concerning this project are contained in the administrative record. Moreover, according to the information provided by defendants, the SSA DOGE team is working on a project involving the unalive master file that does not correspond to what was described in the news. Okay. Testimony from Acting Commissioner Dudek may be helpful as to the various SSA projects that Mr. Dudek has referenced in his declarations and for which he claims the DOGE team requires access to the information. Therefore, I ask the Acting Commissioner to appear at the PI motion hearing April 15th in order to clarify information that's been provided. Despite the informal nature of this letter, it's an order of the court, and the clerk is directed to docket it as such. And then she signed it here. All right, so that was in April 11th. So the court is saying, I have put a restraining order in place so that they cannot access the information. But if we want something more solid and lasting longer, we're going to have to get some proof, some evidence in here and sort it out properly, which is, what you're supposed to do. All right, and then we have another one here. So this is April 17th. As you know, I issued a TRO in the case at 2:12 p.m. March 20th. The TRO orders expires at the time after entry not to exceed 14 days that the court sets, unless before that time the court, for good cause, extends it for a like period or the adverse party consents to a longer extension. By a joint status report, March 27th, the parties advised the court in accordance with Federal Rule of Civil Procedure 65B2, the parties agreed to extend the TRO through April 17th, which is the date of this letter here. All right, so the parties here agreed to that. In accordance with the agreement of the parties, the TRO was extended through April 17th. Specifically, the order extending the TRO states, in accordance with the parties' agreements, the TRO is hereby extended through April 17th. A Random House College Dictionary. Oh, my goodness. Okay. If you see this means the judge is upset. Defines through to include during the whole period of, throughout, as well as to and including. In my view, the TRO clearly remains in effect through the entirety of April 17th, 11:59 p.m., unless I enter an order prior to that time, which supersedes it. Please rest assured that I've been working nonstop to address the challenging issues you've presented. Nevertheless, I do not expect to file my opinion until later today. Until then, the parties shall abide by the TRO. Oh my goodness gracious. All right, despite the informal nature of the letter, this is an order from the court. All right, so the judge was a little frustrated here. So let's take a look then at the TRO. Again, we're doing this because we're trying to figure out what the Supreme Court did yesterday. All right, and the only way to do that is to see what it was that they were overruling from the lower courts. Here we go. So let me see here. This is an older one. So this is the TRO right here. I won't read through all of it, but it is actually pretty concise. All right. So she's saying here, plaintiff's motion for a preliminary injunction is granted here. So the agents, employees, anyone working at the SSA are enjoined and restrained from granting access to any of the SSA system of records. Oh, thank you so much. Containing personal identified information as defined in paragraph 9 hereof. So she did put a restraining order on the gathering of that data. All right. So DOGE here shall disgorge and delete all non-anonymized. So if it's not private or unknown, they're supposed to be getting rid of it. They're enjoined and restrained from installing any software. So no new software. Enjoined and restrained from accessing, altering, or disclosing that information. It doesn't preclude the Social Security from providing members with access to redacted or anonymized data and records of SSA. However, no data shall be provided unless and until the persons to whom access is to be provided have received all training that's typically required of individuals granted access to the data. Right, then number 3 They can provide a DOGE team with access to discrete, particularized, and non-anonymized data in accordance with the Privacy Act. So she's saying, go ahead, give them whatever would be qualified under the Privacy Act. That's fine. The general and conclusory explanations that the information is needed to search for fraud or waste is not sufficient to establish need. So you need to be more specific here. Defendant shall file a status report April 23rd here, and no defendant, team member, or affiliate shall be provided with access to the systems themselves. So it doesn't matter how it's set up. You're not allowed access to the system. Let's see, or a system of records, individuals detailed in here. As to individuals detailed in to SSA from another agency, only DOGE team members whose detail agreements are complete shall have access to any SSA records here. An explanation of why each DOGE defendant, DOGE team member, and or DOGE affiliate is in need of non-anonymized access to that personal information in each SSA data system to which access is sought. So and then she says, I might ask you to do further status reports. This applies to Social Security and every place where those records are. To avoid confusion, she's saying it applies only to SSA employees working on the DOGE agenda. So the request to provide access to 4 DOGE team members is denied as moot here. The temporary restraining order is vacated because it's no longer needed. Council shall meet and confer to discuss whether the government intends to file a notice of appeal, which they did. For purposes of this order, the following definitions apply. This is where we have this kind of this BS that they're kind of playing this game on what different terms mean. But I think it's great. Clarify what your terms are. We should always be doing this. Leave no doubt. So here they're saying you need to file your appeal. So the appeal went to the 4th Circuit, and then it went up to SCOTUS. And it's this appeal off of this preliminary injunction that SCOTUS ruled on yesterday, all right? And they stayed and overruled the case, all right? So that, again, clarifies what we're talking about when we're talking about the Supreme Court's decision. So let's look at the Supreme Court's decision here, now that we know. Now that I've walked you through this journey, very exciting journey here. So let's take a look. This was Social Security Administration here versus AFSCME. Here, application for a stay. So they're asking for the lower court's proceedings to be stopped. So everything in the lower court is stopped until the Court of Appeals decides it. So the application for stay presented to the Chief Justice and by him referred to the court is granted. April 17th, preliminary injunction entered by the United States District Court for the District of Maryland is stayed. All right, so the preliminary injunction, the protections that I just read to you that she put into place are stopped. All right, those are stopped. Pending the disposition of the appeal in the United States Court of Appeals. All right, until the appellate court decides what's going on. All right, for the 4th Circuit and disposition of a petition for a writ of certiorari. So the appellate court for the 4th Circuit, along with SCOTUS, until all decisions have made it through all of the courts. So in the interim, they'll have access to the information. If such a writ is timely sought. Should cert be denied, the stay shall terminate automatically. In the event cert is granted, the stay shall terminate upon the sending down of judgment. Justice Kagan would deny the application. Justice Jackson, with whom Justice Sotomayor joins, dissenting from the grant of application for a stay. Could it speed up the appellate court decision? I suppose. So we're waiting for an appeals merit decision. Yes. Correct. So I've got a couple of paragraphs here right off out of the court that will give us more details on exactly where this case stands. Because again, the last filing out of the Court of Appeals, so they're saying, well, the Court of Appeals needs to make a decision. The Court of Appeals, this is their last filing, has been on May 6th, and the order says a majority of judges in regular active service and not disqualified, having voted in a requested poll of the court to grant initial hearing en banc on the merits of this appeal, it's ordered that initial hearing en banc is granted. We do not know when that hearing is. We have no date. We have no date as of this moment that I have on this paper. So May 6th, they were granted en banc, and the next thing up is a hearing. The fox is still in the hen house. Yeah. Do you think putting all that in place would have made a difference? No, I do not. I think putting that in place would have made us all feel better. But the reality is that information, no. And that could just be my personal take on our personal information. But that's already all out there. Right. Access to the information. Right. Let's look and see. Let's read here what the Supreme Court has. We've got 3 paragraphs and a dissent. So on January 20th, the president signed an executive order establishing the Department of Government Efficiency, DOGE, with the goal of modernizing federal technology and software to maximize governmental efficiency and productivity. The executive order requires agency heads to establish DOGE teams within their agencies and to ensure DOGE has full and prompt access to all unclassified agency records, software systems, and IT systems in a manner consistent with applicable law. So, quite frankly, everybody, the purpose, the goal, the true goal here, if this was true, that'd be great. If we updated our systems and got government systems like lined up and working together so that all of the systems match, that'd be great if they could do that under the law in a proper way. But there is like what the goal is here, which would be great, versus what the actual de facto idea is. So I'm all for that. Yeah, that was the purpose. Can you believe that, Carol? Can you even believe that? Let's just look at that one more time. The executive order requires agency heads to establish DOGE teams within their agencies and to ensure DOGE has full and prompt access to all unclassified agency records, softwares, and systems in a manner consistent with applicable law. Why? Because they're establishing this department with the goal of modernizing federal technology. That's a great goal. We like that goal. I'm pro that goal right there, if that was actually what was happening here. All right, so this is what I would refer to as de jure. That's what's actually written. But in de facto, it's not actually what's happening. Right, hardware, software needs to be universally compatible while maintaining silos. Absolutely, that's right. All right, so here we go, jumping back into it. So April 17th, the district court preliminarily enjoined the Social Security Administration from granting DOGE affiliates access to various Social Security records, subject to certain exceptions. Then en banc, Fourth Circuit denied the government's request to stay the preliminary injunction by a vote of 9-6. The government now seeks a stay from this court. So the Fourth Circuit said, we're not going to pause the protections of the lower court while we go through this process. And so now the Supreme Court is saying, well, we will. When considering whether to grant a stay, this court looks to 4 factors. 1, whether the stay applicant has made a strong showing he is likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent a stay. 3, whether the issuance of the stay will substantially injure the other parties interested in the proceeding. And 4, where the public interest lies. And these are the Enkin factors, and they're quoting Hilton, but these are, if you've been with me for a while, these would be kind of the winter factors, like kicked up a little bit. All right. After review, we determined that the application of these factors in this case warrants granting the stay. We conclude that under the present circumstances, SSA may proceed to afford members of the DOGE team access to the agency records in question in order for those members to do their work. So they're saying, right, so this is kind of like a pregame show. Like, all right, we think you're going to win, We don't know. We don't have all the information, but we think you're going to win. And because of that, we're going to go ahead and pull that protective order. All right, the application for stay presented to the Chief Justice by him referred to the courts granted. April 17th, preliminary injunction entered by the United States District Court for the District of Maryland is stayed pending the disposition of the appeal in the United States Court of Appeals for the Fourth Circuit and disposition of a petition for writ of certiorari if such writ is timely sought. And then, boilerplate language here. All right. And then at the end of that, we have Justice Kagan. She said, I would deny that application. Justice Jackson and Sotomayor dissent. All right. Did the DOGE team have background checks like all federal employees? Great question, Elena. And I tell you what, the DOGE team is refusing to give even basic information to anyone on how they are working. So just basic information required by law to give to someone who asks is not being given. So it's all a big black hole because they won't comply with the requests from FOIA. They're fighting all of them at this point. All right, here we go. Let's look at the dissent, everyone. Let's see what the problem is here with what's going on. Justice Jackson here. So today the court grants emergency relief that allows the Social Security Administration to hand DOGE staffers the highly sensitive data of millions of Americans. The government wants to give DOGE unfettered access to this personal, non-anonymized information right now before the courts have time to access whether DOGE's access is lawful. So it asks this court to stay a lower court's decision to place temporary and qualified limits on DOGE's data access while litigation challenging DOGE's authority to access the data is pending. But the government fails to substantiate its stay request by showing that it or the public will suffer irreparable harm absent this court's intervention. And I would have to agree. I don't see where the irreparable harm piece is coming in. How are they going to be harmed if they have to wait a couple of months for this information, right? They're like, well, we can't update everything if we don't have the information. Like, well, you can wait a couple months, right? In essence, the urgency underlying the government's stay application is the mere fact that it cannot be bothered to wait for the litigation process to play out before proceeding as it wishes. That sentiment has traditionally been insufficient to justify the kind of extraordinary intervention the government seeks. But once again, this court dons its emergency responder gear. It rushes to the scene and uses its equitable power to fan the flames rather than extinguish them. Oh man, Justice Jackson's writing is so amazing. And she's citing her own dissent in Noam v. Doe. Dissenting here, explaining that by granting a stay, the court is allowing the government to terminate the lawful parole status of 500,000 non-citizens before the courts could determine whether such agency action was lawful. Once again, I respectfully dissent. All right, here we go. So the SSA and sensitive data it collects are well known to Americans who entrust their information to that government agency. Social security numbers, birth dates, addresses, bank account numbers, medical records, all of that and more is in the mix. Every person who has received a social security number appears in the SSA's data. And beyond the identification numbers and retirement benefits that bear the agency's name, the SSA also administers a host of other programs, such as Social Security Disability Insurance, which collects detailed medical histories, describing, for example, prescriptions, mental health treatments, and testing results for sensitive data conditions like HIV from applicants and beneficiaries. So, one thing, too, to keep in mind is that I think is important to note is that kind of health information, too, regarding whether or not, there's a pregnancy. I think, that would be information that the government would have access to. Since 1935, the SSA has been collecting, storing, and perhaps most importantly, protecting the information that Americans provide. So this is where I would disagree, everyone. I'm going off-roading here, everyone. This is me personally here, not conspiracy theory. But this is where I would disagree with Justice Jackson. Collecting, storing, perhaps more importantly, protecting that information. I'm not so sure. Some of the most critical safeguards are established in federal law called the Privacy Act, which Congress enacted to protect the privacy of individuals identified in information systems maintained by federal agencies, which I think is an excellent act and an amazing choice here. They did good work. In its findings supporting the Privacy Act, Congress focused on the collection, maintenance, use, and dissemination of personal information by federal agencies, specifically noting that those agency practices directly affect individual privacy. Congress also recognized the harm to individual privacy that can occur from government's mishandling of Americans' sensitive information, harm that can relate to employment, insurance, and credit, among other areas of life. To protect against the significant privacy risks that the government's handling of American sensitive information creates, the Privacy Act regulates federal agencies' collection, maintenance, use, and dissemination of such data. As relevant here, the Act prohibits agencies from disclosing covered data except in narrow circumstances, such as where agency employees have a need for the record in the performance of their duties. All right. Oh, I adore her writing. She does great writing. Domestic workers and farmers as well. Yes, I agree. It should come as no surprise then that the SSA long followed a policy of restricting access to the personal records the agency maintains consistent with the Privacy Act and similar laws. For example, before granting its employees access to SSA data, the agency strictly enforces background checks, training requirements, and agreements outlining sanctions for misuse of data. It is also limiting employees' access to sensitive data to only what they need in order to perform their assigned job responsibilities. All right, now, and she goes on. I'm not going to read her entire dissent here. It's 11 pages. But, she makes a great point. I think it's a very valid point, and the same point that a lot of people are worried about with sensitive information. And, we've got some trust issues here, right? So DOGE was created questionably. We don't have any kind of confirmation that it was created legally. And they're going into all of these different areas of the government and gathering all of this information. So there's a huge trust issue. Also, what's the rush? Like, what's the big rush here? Right? I mean, why can't you wait a couple months? And that, to me, is also the other big question. Thank you, Sin. Yes. Yeah, no oversight. Yeah, it happened so fast. Yeah. Didn't they rename? Right. Well, and there's lots of questions about that. And let me get out my own chart here. So I showed you the organized chart that Lawfare had of all of the DOGE cases. And then here's mine. Here's my closet docket. So let me see here. Because when we're looking through these cases, the problem is we don't have a full affirmation that it's complied with the statute. Hold on here. Oh, and we've got preservation of records issues. Let me just look. I'm flipping through my stack here. We have also teachers here. We have, let's see. Okay. We have expedited discovery here. Crew, that's another big one. This is the one that went to the Supreme Court here. Preliminary injunction. Well, I thought I had put down the name of the number of the statute, but apparently I don't have it. But the point is, they're saying it wasn't created properly. We don't have a ruling on that yet. We have no ruling on whether or not it's complied with the statute. So we don't know if by just renaming it in the format that they used, if that was appropriate or not. They're going to get the names of undercover spies and people in witness protection. That I don't know. That I do not know. I mean, it's that kind of information, right? Well, where's it held? That's the question, right? Is that in the FBI databanks, right? Or CIA information? I mean, that private information is in federal agencies, and I don't know what DOGE is doing in the FBI. NSA, yeah. I don't know. I don't know what they're doing, digging around in there. Anytime the government starts putting together lists, it's disconcerting. Yes, yeah, it is. It's very disconcerting. So a lot of people, I mean, it's overwhelming. I think when you first realize the situation, when you first realize that your information is not protected, it can be very overwhelming. What I try to explain to people though is that, from the start, from this moment forward, now you can make it so that if they have your information, it's harmless. All right, you can do your best that way, and that's the only way you can really protect your information. It's going to get out there one way or another. It's just a matter of when. Some information, who knows, may be kept somehow okay. But with the data breaches and all of those kinds of things that are going on, this is not a conspiracy theory, everyone. This is just, what's going on. This is just, people go into the system. I don't know who's paid attention, but there are universities all over the United States that are getting hacked, and all of the information that they have is being held for ransom, right? I mean, that's happening all the time. So this information out there is, not okay. It's not cool either that we have this committee or this group that's been made that we don't know if they've been made lawfully going after that information, right? Right. So, again, what I say is set your information up in a way that makes it so that if somebody gets your information, it's not going to be harmful to you. So that's the best that can be helpful for you, in my humble opinion as an attorney. Yeah, the calls are coming from inside the house. Yeah, that's exactly right. Cities and hospitals all the time. Right, Jennifer. So, and the thing is here, back when the Privacy Act was put into place and the checks were put into place by Congress, that's great. That's absolutely fantastic. But we're in a different world now. We're in a different world where I would say, you're holding your phone, right? Or, it's right there. Is there access to bank accounts? Is there access to address? Is there access to any personal information on your phone, right? I mean, are you buying stuff from the TikTok shop, which we love? Bank account information, there you go. So like all of this information here that they're gathering, it's like already in your hand. And if it's in your phone, everybody has it. That's how I try to put it. Oh, the USA Patriot Act. I agree, Melly. Yeah. Yeah, and then they sell it. Well, right. I mean, how else, right? If you're just thinking, or you ask a question, you're like, oh, I'm thinking about buying a fedora. And then the next thing you know, on your, words with friends, they're like, ooh, here's a fedora. Maybe you should try it. Like, what? What just happened? What? Gift cards. Yes. Gift cards are excellent. But be careful, because those are also, there's a huge ongoing hacking fraud going with that as well. So I'm not trying to say, put your tinfoil hat on, everybody. No, nobody needs that. Well, I mean, except for fun. Did anybody catch Barrister? Barrister had a tinfoil hat. It looked like a whale. I was like, what are you doing? Like Manda Rose, I think, started it. That was amazing. I mean, you can wear your tinfoil hat if you want. But what I found more helpful is to figure out how to work within the idea that they have your information. How can you still go forward with that? Exactly. I have to say, if you buy gift cards, buy them online from a trusted source. Ooh, great information. That's great information. Yeah. Crayons and a coloring book in my corner. That's funny. But, valid. I mean, it's valid. The real problems here come when, some kind of basic
assistance or basic piece is denied to you because they have access to information they should not have access to. All right, so you're open and honest in what you're writing down for Social Security disability, for health or retirement or whatever. You're being open and honest, filling that paperwork out, writing it out on the computer, whatever, you know what I mean? And you send it in, and then some random place that has nothing to do with anything, like you're trying to go into a park, national park, and we're like, well, you want to go for a hike? And they're like, I don't know. Looks like your left leg was broken about 10 years ago, and we don't want to get sued for liability, so we're not going to let you into the park. Right? You see what I'm saying? Like, those aren't attached. Those don't go together. So why is it now that access is out there with easy knowledge now? And so now I can't go into the park. Like, my whole life goal was to be able to go into the park and see the redwood trees. And now look at that. I can't because my leg got broke in an accident a few years ago. See what I'm saying? Right. Yeah, you can't opt out. And a lot of things you can't opt out of. A lot of things you can't. If your Social Security, if you want a Social Security number, boom, you got to have that information in there. If you need access to disability, boom, that information's there. Or if you retire, boom. I mean, you have to fill that stuff out in order to receive any of the benefits, like a driver's license, that information, boom, there it goes. You're giving it to the federal government. Okay, that's funny. And hiring practices, exactly. Or if, things start turning handmaiden style and there are other questions going on. Yeah. Exactly. Can be used to discriminate against different people. That's right. Yeah. So, I mean, it's access to private information is very invasive. It's incredibly invasive. And so what you have to figure out and work with is, how can that information not be used to cause me harm? And that seems to be something that can appease a lot of the anxiety that's out there. Hello, Kat. Welcome. Yes. So I fully know the information that they, like when I took the bar exam, like they went all the way back to the beginning and they're like, did you use an illegal substance ever? And I was like, no. They're like, wait a minute. You might not have been convicted, but you got to put that all out. So of course you got to write it out. You're like, yeah, I did this. Because for me, it wasn't that bad, but they write it all out. So we could just access that all they want. So let's say I ran for president of the United States. No, that's not a good example because you can do whatever you want and run for president of the United States. Let's say that I was going to become the queen of another country. So, all right. So let's set this up properly. No, that's not going to work either. I don't know. Somehow they were going to award me California. And California's like, we want you to be the queen of California. But then all of a sudden they're like, wow, we looked at your bar application and, it sounds like you're kind of a jerk once. And, boom, you're done. See what I'm saying? I mean, you got to make it so that information, if it comes back to you, isn't going to haunt you. Yeah, who knows? Exactly. Becoming a police officer, exactly. You can have as many felonies as you want, apparently. Yeah. I mean, it's important. You have to be honest when you are filling out anything that says be honest, and you sign your name and it says, I attest that everything is true and honest. You have to do that. But, the exact information, you just have to be careful with how you put it. Yeah, Queen of California, come on. I mean, California's like, no, we're too diva for that. Right. And again, remembering that, and you might say like, oh, I'm very careful with my phone. I don't have any information on my phone. Well, did you turn your GPS off? Have you turned your camera off when you're not using it? Have you turned your microphone off when you're not using it? Have you checked all of your apps to make sure that they don't have access to anything when you're not using it? There's just a lot of layers here to that. Like, and this isn't, again, we're not in a tinfoil situation. We're just this is just kind of how it is. And then how do you go forward and live a wonderful, great life, acknowledging that information's out there. Right. Well, right. Exactly. They know everything about me. Yeah, but I'm boring. Exactly. Make yourself boring, everybody. Make yourself boring. Oh, stay off the radar. It is disconcerting. But again, I would say, and one of the things too that is very distressing for me, one of the areas that I worry about is if somehow the red flags for me are anything that asks you information about your religion. That's a red flag for me. Like my religion, those kinds of First Amendment beliefs to be put into a system could absolutely be used in a way that could be discriminatory for certain jobs or certain locations. That could have a very negative effect, right? So if you fill out information like that and someone's asking you a question, it seems pretty innocuous, but that goes into a federal database, that information could get out there. So I worry about that. Oh, of course. Oh, Prudent Cat. Of course, I'm glad. I'm happy to help as best as I can. All of this stuff is just made so I guess people are like word salad these days, but I don't know. Like I eat a lot of salads. I don't mind salads, but I don't know what the better terminology is. It's just a different language. And so that's, I think very important. Most medical oh yeah, that's a good point, Carol. That's a really good point. It's not a big secret. Well, right, taco salad. See, in my area, because of where I live out in the sticks, there is we're like West Side Story out here with the Catholics and the Protestants. All right. So if you are in the Catholic part of town, you're all right, as long as you're Catholic. But if you are a Protestant, there's like fighting. So I kid you not. So if this is something that you're worried about and you're trying to buy a house, the person selling you the house is like, I heard you're a Catholic, so you're not allowed here. And you're like, well, I'm going to sue you. I'm like, all right, that's fine. But the house will be bought and sold again by the time your 6-year lawsuit makes it all the way through the system, right? So again, that's de jure versus de facto, rare situation, but yet one that, I think about because I'm in such a small little place here. Yes, Moon Sister. Yes, and a lot of our pagans and various other religions along those lines. I think one of the best terms I've ever heard was that they have to stay in the broom closet because it's not safe. It's not safe to come out. And that can be absolutely the same if you are Jewish. Like, I'm talking about Catholics and Protestants. Like, don't get me started on, our Jewish brothers and sisters that are out in the community. Like that can't be known at all. You got to keep it, under wraps for sure. Right, Eugenie, that we know of. We don't know. There might have been some stuff going on. We don't know. But the way this committee was made is hinky. If they had gone through the proper channels and created this committee the way that they were supposed to, they wouldn't be getting sued so much. They'd be like, well, we went through the proper procedures. Here's the committee. We're going in. And it's like, well, we don't think you should have access to that information. This would be a different ball game. But they didn't. They just were like, well, this committee, we're going to just take it and slap a new name on it. And somehow that's okay with procedures. Like, that's not how that works either. Yes. And again, I bring up religion because that was a factor that was used against me personally in one of my jobs because I was outspoken that I didn't think that religious symbols and that should be used in state government location during Christmas. Like I don't care what, if you want all the holidays, do all the holidays. But, I don't think that certain depictions of clearly Christian ideologies should be just like in everybody's face. And that was something that my boss thought was offensive. And that was a problem. That was a problem. So, I mean, you got to branch out. And also it's like you can't have representations for all the religions. There's like, I don't know, 700 religions in the US. You can get like the top 10 though, right? I mean, you could do the top 10. That's all right. You can make a poster. Yes. I mean, that's the area that I have noticed that's easily in my area, because again, I'm out in a red state. I'm a little blue dot in a red state, and that's one of the things that I see is probably the easiest thing to get used against you out here. I'm not saying we don't celebrate Christmas. I'm not saying that. We celebrate Christmas. It's the most wonderful time of the year. Don't get me wrong. All the books come out. All the songs come out. Go tell it on the mountain. I'm not trying to say don't do that. I'm just saying what the law says. There's a law. We have laws. We have rules. Follow the rules. That's what I'm trying to say. That's what I'm trying to say here. There's rules. Coexist. That's right. Or say Happy Christmas. But if you know for sure somebody is, Jewish, you can be Happy Hanukkah. That's what's wrong with that. Or Happy Kwanzaa. Or I just learned a couple years ago, Happy Goat's Day, for the Swedish holidays. Like, just be respectful. Not everybody is going to be like, all right, thanks, Anyway, I digress, but the problem is, again, when it's used against you, which it certainly was in my employment situation, which got very uncomfortable. Right. It got very uncomfortable. And I remember walking away from oh my gosh, everybody, I remember walking away from the Secret Santa situation, and they're like, well, what'd you bring for a present to pass around? And I'm like, well, what? And it was just this terribly awkward situation where I'm like, this just doesn't, like, we're at work. like I've got court in an hour. Like, what are you doing? Awkward. Or festivus. Exactly. They can be everything. You can have everything, I'm just right. So it can be very, very frustrating. Again, that kind of information is something, though, that you could have access to federally, and that could be used against you to discriminate against you. Your health information could be used also for even like pre-existing conditions, if we're in that kind of a situation, or somehow if you're unemployment situation, and they're like, well, here's your prior employment. Like, there can be all kinds of stuff that can negatively affect you for sure. So, you got to just kind of keep an eye on it. So hopefully this helped explain, though, what happened with the Supreme Court, because I felt like when we're seeing the reports and content creators, which they're doing great work, but they're in here and they're like, well, that's it. DOGE has access to your Social Security information. And I'm like, and all of the other information, like, we don't need to stop there. I mean, they've got all this stuff too. So, if we're going to be upset, let's include everything. We don't want the rest of this to fall through as well. Yeah, exactly. Grab a stapler. Well, that's pretty much what happened. And let's just say my Secret Santa gift was the one nobody wanted. Awkward. I didn't know, right? How are you tracking the cases? Yes. So I have several methods because I'm just, I just do. I've got Lawfare here. This is the website. They have a pretty good system there. Just Security also has a good site, Just Security. Also, the Blue Sky, or the Sky of the Blue, have several people tracking different cases. So if you've got certain cases in your mind, the other thing too is I really look a lot for the new cases from Lawfare and various other places, but the cases that I already have, I just go through a batch at a time. I do about 25 cases that I'll update about, every other day. And so that way I get through the cases. And the way I've got them organized on my closet, like if I'm waiting for an order, then I'll just look those up on the dockets. I'll just look up the ones that have had hearings and look and see if they have orders. Like, for example, the DOGE cases here, like I'll pull all the DOGE cases off, and then each case number, I'll just pull it up and see what's going on. And then I'll make a little note. You probably can't tell, but I'll make a little note of what's happening. And then this is how I know which date I checked it. So I have another system so that I know, like this one I checked about 5 days ago. So that's what that symbol means. So that's kind of how I keep these in track. But Lawfare does great work. Just Security does great work. They do, seriously, they're doing amazing work out there. So if you want to keep track of that. Also, to some degree, the wiki, they're not too bad. They're not too shabby. I don't trust the wiki all the way, but they're not doing too bad either. So that's kind of how I'm keeping, yeah, exactly. I'm keeping track of it. The most important thing for me is that I make sure any new cases I grab as quick as I can so they don't get lost, because once they're in my system, then, I can track them. But if I don't even get it into the system, if I miss one, then I go back, I'm like, what happened here? So yes, very careful about that. But with that, my friends, I will go ahead. For now, we've hit our 90-minute mark. So I'll go ahead and say fare thee well for the moment. I will be back again tonight, 8 p.m. We have part 2 of the Pam Bondi ethics complaint. I will have that up tonight. We'll go through the second part of that and get the details of that. So thank you all for coming and hanging out with me. I appreciate it so much. I hope you have a great day. Hopefully this was helpful to you, so you have a good idea of what's actually going on here. I will post this up to the tube as quick as I can. So yeah, bear with me. Take care, everybody. And as always, moderators, thank you for your hard work. I'm forever grateful to you.